trial ni Chief Justice Renato Corona at samantala tunghayan naman natin ang press briefing na isinasagawa ng prosecution team.
Binabago, walang expansion. But the witness is very, very critical because it goes into the motive on why the Chief Justice actually committed those acts he is accused of. Importante yung motibasyon, yung intent, kung bakit niya ginawa yung paglabag ng konstitusyon at kung bakit nagkaroon ng betrayal of public trust. That is the reason. Kapag sa maraming halimbawa, kapag nagkakaroon may isang murder o may napapatay, we only put the elements of the crime. But you don't put the reasons or the motive kung bakit pinatay niya yung isang tao. But in this case, this clearly will establish yung motivation on the part and the consideration, the reason for which the Chief Justice ay na-induce para labagin yung kanyang panunumpa. Ito yung dahilan. So, hindi po namin malaman kung bakit hindi ito tatanggapin ng Senate Impeachment Court.
Ang pinag-uusapan po sa Article 3, yung pinaka-buod niya o pinaka-puso po niya, yung kawalan po ng integridad at katapatan ni Chief Justice Corona. At palagay namin, pag tumanggap ka po ng benepisyo sa isang litigant o mga may kasong hinaharap po sa inyong sala o sa harapan po ng isang justice na pwede siyang mag-decide dun sa kaso ninyo, palagay ko maliho yung tumanggap po ng benepisyo. At yun po ipapakita po natin, sabi po ni Congressman Kimbo, bahagi po ng motibo niya yon. Kaya siya umakto ng ganun. Andun po sa reklamo po namin yung aligasyon na kaya nga bumabaliktad siya sa PAL-FASAP case at dun sa pamamagitan lang ng isang sulat ng isang abogado ay bumaliktad na po dun sa kasong PAL-FASAP. Yun po ang nasa ilalim nun eh. Kung tinanggal nyo po, hindi nyo kami binagyan ng oportunidad para ipresenta po yon. Ano mangyayari po sa kaso? Hindi po ata tama na ililimita po yung kung sa criminal case nga, sabi ni Congressman Kimbo, pwede yung motibo kahit hindi naka-allege sa complaint. Ano pa kaya sa impeachment complaint na dapat mas relax po yung rules of procedure po rito?
So, para maging maliwanag, hindi po ito bagong charge. Hindi po ito bagong charge. Kagaya ng sinasabi ng iba, meron uling panibagong sinisingit yung prosecution. Hindi. Ang testimonya po ng PAL representative ay pumapasok kung bakit nag-flip-flop si Justice Corona. Ganun kasimple lang po yan. At paano namin papatunayan ito? Dahil meron po siyang natanggap ng mga benepisyo. Ganun kasimple. Kaya hindi namin maintindihan kung bakit ayaw ilabas o ipalabas ng impeachment court itong ebidensyang ito.
Sirs, Johnny Banyas po from DSMM. Yung ibig sabihin po bang na-deny na yung unang witness ninyo, lahat ng witness nyo regarding Article 3 ay i-deny na rin? And then if ever ganun na mangyayari, are you willing to amend yung Article 3 para mapayagan kayo makapagpasok ng mga witness and evidences?
Well, anyway, nagsimula na po yung... we feel that the decision is absolutely unfair. And it is not founded on basic jurisprudence that we have.
Let's go back to the floor. Nagsisimula na po.
To the Honorable Presiding Officer, the prosecution takes exception to the ruling regarding the matter. And it is the position of the prosecution that with the presentation of the witness from PAL, the prosecution does not expand the complaint as stated. For the following reasons, Mr. President. As to the relevancy to the Article 3, it proves consideration, inducement, motive. To us, the motive here is very, very important, crucial, critical to an impeachment proceeding. The motive for what? The motive for the Chief Justice in flip-flopping. The motive why the Chief Justice acted on a mere letter based on paragraph 3.3 of the article, the motive why the Chief Justice involved in the administrative matters that are alleged. So we allege here the flip-flopping, Your Honor. We allege the mere acting on a letter by Attorney Mendoza. But to us, it is very important to prove the motive in an impeachment
You should
proceeding.
have alleged bribery. if you understand the meaning of bribery.
Yes, we did not allege that,
Yeah,
Your Honor.
Precisely, but that is the tendency of the evidence that you are presenting.
But, Your Honor, the very heart of Article 3 is integrity, providence, and independence.
Correct.
Probity.
Correct, but you limited your charge for lack of competence, probity, and integrity in 3 ways. Mr. Counsel, I do not know how you learned your art of pleading. I do not fault you, but I'm basing my ruling on your allegations and nothing more. And if you are going to insist on your position, I say I will not change the ruling.
We respect that, Your Honor. Can I just finish my manifestation?
Now,
with utmost
you
respect.
want me to order you to amend your articles of impeachment and send it back to the House?
We wouldn't know, Your Honor.
You have a choice.
We respect that, Your Honor. But I just want to finish, Your Honor, that
Yes.
technicalities cannot be permitted to prevail in such an important proceeding.
This is
such
not
as,
a
technique,
for heaven's
this
sake,
impeachment
this is
proceeding.
not a technicality. The grounds for impeachment are very clearly stated in Articles 11 of the Constitution. We are already very liberal. You're in effect asking us to review the decisions of the Supreme Court. Who are we to review the decisions of the Supreme Court? But we allow it in order not to embarrass you. But you are going too far.
We respect, of course, we have a very high respect.
Do you want me to lecture to you more?
No need, Mr. Presiding Officer. Anyway, Your Honor, we just want to put that on record as the position of the prosecution.
Well, I
That's
will tell
all.
you, if you want to allege the receipt of gifts, the receipt of valuable things by the respondent, then amend your articles of impeachment because you are in effect alleging a crime, which we will have to evaluate whether it is a high crime. You are in effect alleging that he was bribed to make that decision.
Yeah, but Your Honor, the charge here, the ground is betrayal of public trust. Anyway, Your Honor, thank you for that, for giving us opportunity. We just want to thank the Honorable Presiding Officer for giving us that opportunity just to state for the record the position of the prosecution of the matter. And now, may we request that one of our private prosecutors be recognized again. Attorney Marlon Manuel.
Attorney Marlon
Manuel, Your Honor.
Manuel.
Thank you.
Proceed.
Thank you, Your Honor. We will make a tender of excluded evidence, Your Honor, under Rule 132 of the Rules of Court. And we would like to state for the record that if had PAL Vice President for Sales, Enrique Javier, been allowed to testify, he would present the following documents, which were required to be submitted pursuant to the subpoena that was issued. First, Your Honor, and this was previously marked as Exhibit Septuple P, this is a certification and compliance signed by Enrique P. Javier saying that Platinum Card number A752 was issued in the name of Corona Renato C. The date of issuance is December 2010 and the expiry date is December 2011.
Your Honor, please.
Well, wait a minute. I will allow the manifestation. What is the pleasure of the...
Yes, Your Honor. Thank you very much, Your Honor.
Well, practically, this is adducing evidence through a manifestation, Your Honor.
This is a tender of excluded evidence, Your Honor.
The proper of evidence, Your Honor, is proper only when there is a witness on the stand and a question had been propounded to him, and an objection is made, thereby sustaining the objection. So that if the witness was not prohibited from further testifying, then his counsel or the counsel conducting the examination may make a proper of evidence. That is the situation where that rule applies, Your Honor.
Your Honor, may we allowed to respond?
Yes.
Under Rule 132, Section 40, if the evidence excluded is oral, the offerer may state for the record the name and other personal circumstances of the witness and the substance of the proposed testimony. So this is precisely the situation that we have now.
That, Your Honor, please.
We have discharged the witness.
Yes, Your Honor. That is why we are making the manifestation for the record on the substance of the testimony of the witness.
This is if Your Honor, please, this is unprocedural. This is violative of the cardinal rules on evidence, Your Honor. As we have stated, that can be done only when there is a witness on the stand, there is an objection, and the objection is sustained. So there could be a proper of evidence.
Anyway, counsel, even if I'll allow the matter to remain in the record, it is, to me, it's not evidence yet. So, let it be.
Thank you, Your Honor. Your Honor, based on...
What is a platinum? I don't understand what is a platinum.
Yes, Your Honor. A platinum card, Your Honor...
No, you cannot state it for yourself.
I am not stating it, Your Honor.
You're not under oath.
Yes, Your Honor. But I am referring to a record showing the benefits of a PAL platinum card. And this is based on the certification...
That is improper for counsel to state. You should have presented a witness for that purpose.
Your Honor, I am referring to an annex of the certification of the witness. This was already marked, Your Honor.
Let it stay as it is. The ruling of the chair stays.
So may we be allowed to continue with the manifestation, Your Honor? The PAL Platinum card was used based on the certification and compliance for 4 round-trip travels. 1, Manila-Guam, Guam-Manila, dated April 20 and April 24, 2011, respectively. Manila-Singapore, Singapore-Manila, April 15, 2011 and April 19, 2011, respectively. Manila-Honolulu and Honolulu-Manila, December 25, 2010 and December 30, 2010, respectively. Manila-Hong Kong and Hong Kong-Manila, December 18, 2010 and December 21, 2010, respectively. And then the platinum card number A753 in the name of Corona Maria Cristina R. Date issued December 2010, expiry date December 2011. And there are 12 round-trip travels recorded in the certification and compliance. Manila, Jakarta, Jakarta-Manila, July 10, 2011, and July 15, 2011, respectively. Manila-Guam and Guam-Manila, April 20, 2011, and April 24, 2011, respectively. Manila-Singapore and Singapore-Manila, April 15, 2011, and April 19, 2011, respectively. Manila-Bangkok and Bangkok-Manila, March 4, 2011, and March 7, 2011, respectively. Manila-Honolulu and Honolulu-Manila, December 25, 2010, and December 30, 2010, respectively. Manila-Hong Kong, Hong Kong-Manila, December 18, 2010, and December 21, 2010, respectively. Manila-Bacolod, Bacolod-Manila, July 28, 2011, and July 28, 2011, same dates. Manila, General Santos and General Santos, Manila, June 3, 2011, and June 4, 2011, respectively. Manila, Cebu and Cebu, Manila, March 18, 2011, and March 19, 2011, respectively.